Okay, let's unpack this. How does a bill actually become law in India? I mean, we all sort of know the basic legislatures passing laws and all that, but what's the real story behind the governors and, yeah, the president's involvement,
Yeah.
giving their nod?
Yeah, it's such a foundational part of how our country works, isn't it?
It really is. And yet, understanding the ins and outs of this assent process, it can feel like trying to solve a bit of a constitutional puzzle.
You've really hit the nail on the head there. Whether you're, say, prepping for an important meeting where these legal bits might pop up,
Hmm.
or maybe you're trying to properly grasp the complexities of Indian federalism, how it really operates.
Right.
Or maybe you're just curious about, the engine room of our government. The specifics of legislative assent, they can be surprisingly intricate.
Uh-huh.
And that's exactly what we're diving into today.
Perfect. And our main guide on this journey is, well, it's a fascinating document. The Supreme Court judgment, State of Tamil Nadu v. Governor of Tamil Nadu. No, this isn't just some dry legal ruling, is it? It's actually packed with a really detailed historical and constitutional breakdown of how bills get that final stamp of approval, like the ultimate insider's look.
Absolutely. It's a rich source. And our mission for this deep dive, it's pretty straightforward, really. We
Yeah.
want to pull out the most crucial insights from this Supreme Court analysis,
Okay.
focusing on the powers and, crucially, the limits on those powers held by both the governor and the president when they're looking at state
All
bills.
right.
We'll be zoning in on the real scope of their decision-making, the timelines involved in this whole process, and that all-important question:
Yeah.
can these decisions actually be reviewed by the courts?
Okay, so let's start at the beginning then. Lay the groundwork. Where did this whole idea, this concept of needing assent for a bill to become law, where did that even come from in our legal system?
Well, what's fascinating, if you look back, is that the concept of assent, it actually has roots stretching way back to documents drafted during our independence movement.
Oh, really? That far back?
Yeah. Even in those early visions for India, this idea of a final approver stage was, it was present. Then later, when the Constituent Assembly got down to actually debating Article 200,
Which is the key one for the governor, right?
exactly the heart of the governor's role in this, there were already significant discussions happening right then about what this power should really entail, what it should look like.
Right, so it wasn't just like tacked on at the end. And this role, it hasn't exactly stayed static over the years, has it? I seem to remember various commissions have looked into it.
Precisely. And if you sort of connect this to the bigger picture, how our governance has been reviewed and refined over time, several key commissions specifically examined Article 200 and the governor's authority.
Like who?
Well, you've got the first Administrative Reforms Commission back in 1966, then the Rajamanar Commission in 71, followed by the pretty well-known Sarkaria Commission,
Ah, yes, Sarkaria.
and later the Punchy Commission. Each one of these bodies, they offered recommendations on, the extent of the governor's discretionary powers and how the whole assent process could potentially be improved, made more efficient, perhaps.
Okay, so let's picture it. A bill has made its way through a state legislature, it's passed, and now it lands on the governor's desk. Under Article 200, what are the actual options? What can the governor do?
Okay, so Article 200 basically lays out three main paths. First, the simple one. The governor can grant assent. That's it. Bill becomes law.
Done deal.
Done deal. Second, the governor has the option to withhold assent, which, as you can imagine, puts a stop to the bill, at least for the time being.
Okay.
And the third possibility is that the governor can reserve the bill for the consideration of the president, send it upstairs, so to speak.
Right. Now, this is where I think a really key question comes up. How much freedom does the governor really have here? I mean, can they just decide on their own, nope, not signing this, regardless of what the elected state government, the Council of Ministers, is advising?
This is such a crucial point. And the Supreme Court judgment we're looking at, it delves into this quite deeply. What's really telling, I think, is the history here.
How so?
The phrase, "in his discretion," which was actually part of the equivalent rule in the old Government of India Act of 1935.
Uh-huh.
That phrase was deliberately removed from the main body of Article 200 during the Constituent Assembly debates.
Ah, okay. So they consciously took that out.
They consciously took it out. So the big takeaway here is that the Constitution deliberately limited the governor's independent power when it comes to bill assent. The clear intention was to tie the governor's actions much more closely to the advice of the elected government.
That's actually a pretty significant change from the earlier act. So, okay, when a governor does withhold assent, is that the final word? Is the bill just dead then? Or are there others
Now,
to
it's
name?
not necessarily the end of the road for the bill. The first proviso to Article 200 is absolutely vital here. It states that if the governor chooses to withhold assent, they must return the bill to the state legislature. And not just return it, but return it with a message requesting that they reconsider it. They can even suggest specific amendments.
Okay, so it goes back.
It goes back. Now, here's the critical part. If the legislature then repasses the bill, whether they accept those suggested amendments or not, they could pass it exactly as it was and sends it back to the governor.
Then what?
Then the Constitution is very, very clear. It says the governor shall not withhold assent therefrom.
Shall not withhold? Okay, yeah, that sounds pretty unambiguous.
Yeah.
So basically, the governor doesn't have an absolute veto power over bills passed by the state legislature.
Precisely. No absolute veto. And the Supreme Court has strongly reinforced this understanding, particularly in the state of Punjab case.
Yeah.
That ruling really cemented the mandatory nature of this procedure.
The procedure in the proviso.
Yes. The governor must follow the procedure in the first proviso, sending the bill back for reconsideration if they initially decide to withhold assent. It confirms absolutely that the governor cannot just kill a bill passed by the state legislature through a permanent veto.
Now, what about that third option, reserving a bill for the president? Can a governor do that after they've already withheld assent and the state legislature has gone through the whole reconsideration and repassing process? That kind of feels like it could be a loophole, maybe, to get around that shall not withhold requirement.
That's a very sharp observation, and it's a point the Supreme Court has directly addressed, likely to prevent exactly that kind of circumvention.
Right.
The court's position is quite firm on this. The governor cannot reserve a bill for the president's consideration after initially withholding assent and after the bill has been repassed by the state legislature.
Okay.
Once that bill comes back to the governor after being reconsidered and passed again, the only constitutionally permissible action left for the governor is to grant assent. Period.
Okay, that really clarifies the boundaries of the governor's role quite a bit. But let's talk about when a bill is legitimately reserved for the president under Article 201. What happens then? What's the president's role in that scenario?
Right. So when a bill is reserved by the governor, it moves up to the president, and it then falls under the purview of the union executive's discretion, as Article 201 outlines.
And what guides that discretion?
Well, this is where those commissions we mentioned earlier, Sarkaria and Punchy, offered some important recommendations. They suggested that while the union government will naturally look at the bill from various angles,
Sure.
mere policy differences on subjects that are primarily on the state list, things that are the state's business, those shouldn't typically be grounds for the president to withhold assent.
Ah, okay. So it's not just about whether the center likes the policy.
Exactly. The major exception would be if the bill is clearly unconstitutional. The power of presidential assent here is really intended more as a check, a mechanism to ensure some uniformity maybe between central and state laws, especially in areas of shared interest or concurrent list subjects.
Right. Makes sense.
And also to safeguard national unity. It's not meant as a tool just to block state legislation because of differing policy views on state subjects.
Yeah.
Both Sarkaria and Punchy also suggested specific timelines for the president to actually make a decision on these reserve bills.
Timelines. Yeah, that seems crucial in all of this, especially when we're dealing with legislation that can directly impact people's lives. What does the Constitution actually say about how quickly the governor and the president need to act? Is there a deadline?
This is an interesting point because the main text of Article 200, the part describing the governor's initial options, doesn't actually specify a hard time limit. No deadline to grant, withhold, or reserve.
Really? None at all.
Not in the main clause. The only place where time is explicitly mentioned is in that first proviso we discussed, the one about returning the bill. It uses the phrase, as soon as possible.
As soon as possible. That sounds a bit vague.
It does, but the Supreme Court has stepped in to interpret what as soon as possible means in practice. And they've established certain expectations, suggesting timeframes for the governor's actions. Generally, they've indicated a period of around 3 months initially,
Okay.
and then perhaps 1 month after the bill comes back after being repassed by the legislature.
So basically no indefinite open-ended delays are allowed.
Precisely. The Supreme Court has made it very clear that undue delay, or just sitting on bills, inaction by the governor in making a decision, that is subject to judicial review.
Right.
And similarly, for the president's role under Article 201, while that article itself doesn't lay down a specific time limit, the Supreme Court, often aligning with guidelines issued by the Ministry of Home Affairs, has also indicated a similar time frame, generally around 3 months for the president to decide on reserve bills.
And if it takes longer?
Importantly, they've also said reasons should be provided for any significant delay beyond that suggested time frame. Accountability, you see.
This brings up a really fundamental question then. Can the courts even step in if it looks like a governor or, the president isn't fulfilling their constitutional duties properly in this whole process? Is their decision-making actually subject to judicial review?
Absolutely, yes. This is really a cornerstone of our constitutional system. There are landmark judgments, cases like S.R. Bomai, Rameshwar Prasad, and more recently, Nebam Ribia.
Heard of those.
They have firmly established the principle that no constitutional authority, doesn't matter how high up, operates completely beyond the reach of judicial review by our constitutional courts, the high courts, and the Supreme Court.
Okay, but what about the special protections or immunities? I think it's Article 361 that gives the governor certain protections. Doesn't that shield them?
That's a fair point. Article 361 does provide certain personal immunities to the governor. However, the Supreme Court has clarified this over time. These protections don't extend to shielding actions that are clearly unconstitutional,
I see.
especially when those actions have a wider public interest dimension, which deciding on legislation certainly does. The courts can intervene if there's evidence of, say, malified intent, bad faith, or arbitrary decision-making, or actions that just flat-out contravene the explicit provisions of the Constitution.
And specifically regarding reserving bills, can the court look at that decision?
Yes. And specifically on the point of reserving bills, the Supreme Court has, in fact, disagreed with an earlier view that suggested the governor's discretion in this area was completely beyond judicial scrutiny.
Oh, okay.
The current understanding is that reserving a bill is part of the legislative procedure. And like other procedural aspects, it can be reviewed if the constitutionally prescribed procedures aren't followed properly, or if that power is being misused.
That's actually really important to know, that there are checks and balances in place, even there. So flipping it around, what would be considered legitimate grounds then? When is it okay for a governor to reserve a bill for the president, or for the president to potentially withhold assent?
Right. So legitimate reasons for a governor to reserve a bill would typically include situations where, for instance, the bill might seriously undermine the powers granted to the state's high court. That's a big one.
Okay.
Or if there's a clear possibility of it conflicting with an existing central law, especially on a subject in the concurrent list where both the center and states can legislate.
Makes sense.
Or perhaps if the bill is perceived to pose a significant threat to fundamental democratic principles or the overall basic structure of the Constitution.
Yeah.
But, and it's important to reiterate this,
Yes.
simply withholding assent, just saying no, without following that procedure of returning the bill for reconsideration, that's viewed by the court as effectively an absolute veto, which, as we've established, is not permissible.
Got it. And if a bill is reserved because of worries about its constitutionality, is there a specific process that's usually followed then?
Yes. When a bill is reserved mainly due to concerns about it being patently unconstitutional, both the Sarkaria and Punchy commissions recommended, and the Supreme Court has supported this idea that it would be appropriate, perhaps even desirable, for the president to seek the opinion of the Supreme Court on the matter. There's a specific provision, Article 143, that allows the president to do this.
Okay, so they can get a legal opinion from the top court itself.
Exactly. It allows for a proper judicial assessment of the bill's constitutional validity before the president makes a final decision on assent.
Now, we've been talking a lot about the Supreme Court judgment in the state of Tamil Nadu v. Governor of Tamil Nadu case. How does the actual situation in that specific case illustrate some of these principles we've been discussing?
Yeah, the Tamil Nadu case provides a really concrete, tangible example of these principles in action. What happened was the state government went to the Supreme Court because several bills were essentially stuck, awaiting the governor's assent for quite some time.
Right, the delay issue.
The delay issue, exactly. And in a very significant part of their judgment in this specific case, the Supreme Court basically declared that 10 of the bills that had been repassed by the legislature after initially being withheld or returned were deemed to have received assent.
Just like that, deemed assented.
Deemed assented to, precisely because of the governor's extended period of inaction on them after they were repassed. This directly demonstrates that crucial point we discussed earlier about the governor's constitutional obligation to grant assent to a bill, once it has been reconsidered and passed again by the state legislature.
Wow. So the court essentially stepped in and said, look, because of this undue delay, because you didn't act when you were constitutionally bound to, these bills are now effectively law.
That's the essence of it. And it really underscores the importance of the governor's oath. The oath they take to preserve, protect, and defend the Constitution and the law, and to act in a way that serves the well-being of the people.
Yeah.
Their actions, particularly in relation to Bill Assent, must be guided by these constitutional duties, not by, political considerations or just prolonged inaction.
Yeah. Oh, okay, this has been a genuinely insightful deep dive. It clarifies a really important, sometimes murky aspect of our legal framework. For someone listening, what would you say are the absolute key takeaways they should remember from all this?
I think the most crucial points to hang on to are these. First, the governor's power to independently decide on granting assent, their discretion, is actually quite limited, especially compared to what some might assume.
Right.
Second, there are expected timelines, even if not always rigidly defined in the text, for both the governor and the president to act on bills.
Yeah.
And crucially, delays are subject to judicial scrutiny. Third, remember, the governor does not possess an absolute veto power over legislation passed by the state legislature. That shall not withhold clause for repassed bills is key.
Very important.
And finally, I'd say the entire process, the way it's designed, is intended to be a collaborative one, operating within the checks and balances set up by the Constitution, involving the governor, the state legislature, and sometimes the president.
What's one thing that really stood out to you as particularly interesting or maybe even a bit surprising as we've gone through the details?
Well, what I find fascinating is probably the delicate balance the Constitution tries to strike here. It looked like a simple step, right? Granting assent.
Yeah, just sign it.
Just sign it. But it's actually this carefully calibrated function with really specific constraints and expectations, especially that mandatory requirement to assent to a bill that's been repassed. That and the clear lack of an ultimate veto power for the governor. I think that might be surprising for quite a few people.
Yeah, I think you're right. So why should our listeners care about all these, seemingly technical details? What's the real-world relevance of understanding this whole assent process?
Oh, understanding this is absolutely essential, I believe, for anyone who wants to be an informed participant in our democracy. It really shines a light on the dynamics, often complex, of the relationship between the central government and the states, the core of our federal structure.
True.
And it highlights the crucial checks and balances that are built into our Constitution, designed specifically to prevent any single arm of government from becoming too dominant in the legislative sphere. Ultimately, it's about understanding how our laws are made and, just as importantly, the safeguards that exist within that process.
Okay, finally then, let's leave our listeners with something to really chew on, a provocative thought maybe. Considering all the complexities we've discussed and let's face it, the potential for friction and tension in this process of bill assent, how might these constitutional mechanisms need to adapt or evolve in the future? Could they change to better serve the needs of a nation as diverse and dynamic as India? Or perhaps, turning it slightly, what are the broader implications of the Supreme Court seemingly stepping in more frequently now to clarify these powers and limitations? What does that mean for the future of legislative relations between the Union and the states?
Definitely food for thought. How does this balance continue to evolve in practice?
Exactly. Something to mull over.